My name is Kyle Kaufman, and I'm an attorney at HKK Law Offices. We practice family law and estate law, and that includes things like divorce, child custody, child support, termination of parental rights, wills, trusts, guardianships, and adoption. But we are more than just a law firm. We believe in transformation. We find that people that we work for and that we work with leave us feeling more confident in themselves, in their relationships with their family and their kids, and in their finances, and ultimately more confident in their purpose in life. That has a positive impact in our communities, and that is what makes us excited. In this video, I want to talk about what courts consider when they are deciding custody. Most custody matters come up in the context of divorces or situations where parties have a child outside of marriage, and they now have disputes about who should have legal custody of the child. Now, in Wisconsin, where we practice, there are some special things to consider when we talk about custody. The first thing you need to know is that in Wisconsin, custody is about decision-making. It is not about the physical placement of children. Legal custody involves the process of who gets to make major decisions in your child's life, and for most people's purposes, these are decisions that relate to things like medical care, school choice, religious upbringing, and extracurricular activities for your children. In Wisconsin, there is a legal presumption that joint legal custody is in the best interest of your child. What that means is that the law states it is already determined that it's in the child's best interest, that both parents have a say or decision-making authority when it comes to major decisions for your child. The presumption, however, is a rebuttable one. And that means that a person who wants sole legal custody over decision-making can petition the court and ask for sole legal custody. Now, in that scenario, that person would have to prove that certain circumstances exist to warrant awarding one party the authority to make all the decisions. My hunch is that some folks watching this use the word custody in the context of physical placement. So I am also going to talk about physical placement in this talk. The factors, frankly, that go into a court deciding legal custody and physical placement are the same. So unlike legal custody, which relates to decision-making, physical placement is answering where the child is actually living, and what most people would say when they have 50-50, what they're referring to is, I have my child half the time. So unlike legal custody, where there is a presumption that joint legal custody is in a child's best interest, when it comes to physical placement in the state of Wisconsin, there is no presumption that says equal shared or joint physical placement is in the best interest of the child. The statutes in Wisconsin do say that both parents should have periods of placement, unless there's evidence that placement with one parent would endanger the child's health, well-being, and safety. So what I want to do now is get into the factors that a court does look at in determining how to make an order on legal custody and on physical placement. The list of factors are enumerated in the Wisconsin statutes. When I talk to clients about the factors that a court considers, I tell them that about half of those factors are about a parent and the other factors are about the child. What I've done in my practice is to take the factors and I put them into a chart. And I use that chart and I list out the 14 different factors that a court looks at. And I have two columns next to those factors. One column is for one parent and the other column is for the other parent. And then I use those columns to track as I'm going along and keep notes as to what applies to each parent, what the relevant facts are that are available that I know of and that might relate to this factor. I want to be clear that this is not about mudslinging, it's not about putting the other parent down, and it's not about winning. What this is about is doing what is right and what's in the best interest of the child. And that's what the framework for all of this is. Now, the first factor that a court looks at is the wishes of the parents. And the parents can express their wishes as to what they want through a stipulation that they present to the court. And they might both agree on something and they can verbalize their agreement to a judge or they can put it in writing. Now, parents can also tell a judge what they want by submitting what's called a parenting plan. A parenting plan is a written document, and it lists out everything that they want for their child. In the parenting plan, they can describe the specific placement schedule that they want. They can tell us what school they want the child to attend, what doctor they prefer for their child, how the transportation will work between the parents, and other things of that nature. So both parents can put their proposal in writing, and they can submit that to the court. What I have found here under this factor is that it's helpful to be detailed in your parenting plan. So if you're going to take the time to submit the plan to the court, do it with details. So the court actually has something that it can hang its hat on and say, I've reviewed the plan, and I think it's a good one, and I'm going with this plan. The next factor to consider is the wishes of the child. This is really a tough one because I have a lot of clients that come to me and they ask me, well, when does my child get to talk to the court? Or at what age can my child decide the schedule? Or is it okay if my child writes a letter to the court? Now, my experience in doing this over 20 years is this, that children, although they can be witnesses, courts protect them really at all costs. Courts do not want children coming into a courtroom. They don't want to involve them in their parents' dispute. Makes sense. Could be harmful to them. Now, kids might write letters, but courts don't receive those letters in my experience. And here's what you need to know. There's no age in Wisconsin where a child can decide custody and placement issues. So how does a child's wishes then come into the record? And how can a court consider it? The court will appoint a guardian ad litem. Now, that's an attorney who's appointed to represent the best interests of the child. And that person can communicate to the court what the child wants. Our statutes also allow a child's wishes to be communicated by another appropriate professional. Now, the statutes don't define what that actually means, but in my experience, what I've seen is that it could be a child's counselor, it could be a doctor. I've even seen it where it's a teacher who's coming in and telling the court what a child has expressed and wants. Another factor that the court considers is the cooperation and communication between the parents. Now here, the court's going to ask whether one of the parents is unreasonable, if they're unreasonably refusing to cooperate or communicate with the other parent. This factor is really about how well do the parents get along and co-parent. The next factor that a court looks at is whether the parents can support the other parent's relationship with the child, and the court will look at whether the parents encourage and facilitate frequent and continuing contact with the child. And the parent will question whether one parent is likely to unreasonably interfere with the child's continuing relationship. So I've given talks before about parents using kids as tools to get back at the other parent or using the child to get what they want from the other parent. That, of course, is bad conduct and something that I would never encourage a client to do. The court, in this circumstance, is questioning and looking at how well do you support the relationship with the other party. And if you don't support the relationship between your child and the other party, then you ought to have some really good reasons for it. And those good reasons could exist, but you need to have supportive information and evidence of that to show that it's not a good idea to support the relationship. So, for example, if a parent was abusing a child, that would be a situation, right? So make sure you have reasons ready if you're not supportive of the relationship, because you need to explain that to the judge. A factor that the court will look at is the interaction and interrelationship of the child with his or her siblings and any other person who could significantly affect the child's best interest. Now, this might extend to other family members that live in the home, and sometimes that includes grandparents, step-siblings, step-parents, and people like that. In today's world, we have more blended families and relationships and marriages that are second or third relationships, and so kids these days have more complex and diverse relationships. So it's very important that you're identifying how those relationships, those people that have stepped into your child's life or have been a part of it, affect your child, and whether they're healthy relationships. And if they're not, those factors are something that a court will look at. Another factor that the court wants to know about is how well the child actually interacts and interrelates with each parent. The court's going to question this and look at the history of the parenting, including the amount and the quality of time that each parent spent with the child in the past. Now, there's a misnomer here that the only thing to look at in a custody and placement case is what's happened most recently. But this factor, and the statutes obviously tell us not, right? Because it says that the court does look at the entire history here. Now, this factor goes on to state that it will look at any necessary changes to the parent's custodial roles and lifestyle changes that a parent proposes to make to maximize placement with the child. So for the parents that are listening to this and wondering and concerned, thinking, hey, I was the parent that worked in the relationship and I didn't get to spend as much time with my children, is that going to be counted against me? The answer is that it's just part of the history. We can't change that. What the court is going to look at, however, though, is how well you did under those circumstances and how involved you were, and if you're willing to make changes in order to make yourself available now for the child. So you want to consider these lifestyle changes. It could be working less, it could be other lifestyle changes, it could be ending certain relationships or refraining from excessive alcohol or drug use. There are many lifestyle changes that somebody could make, If you're a big golfer, for example, and you like to golf every Saturday and Sunday, maybe you're not going to do that anymore so that you can maximize time with your child. So look at how you intend to operate in the future, not just based on the past. Now, a court wants to know whether a parent has had or does have a significant problem with alcohol or drug abuse. The court is also going to extend this factor to look at whether a parent's significant other has a problem with drug or alcohol abuse, and it also extends to other people who either currently live in the home with the parent, they've resided in the home in the past, or they intend to reside in the parent's home in the future. So again, the important takeaway here is the court is not just always concerned about the parent, they're also just overall concerned about the environment where this child is living and growing up. And so they're going to look at the parents directly. They're going to question, what are the parents doing? Are they abusing alcohol and drugs? And what about the other people that live in the home or intend to live in the home? Or historically, looking back, was this child exposed to other people who consumed alcohol and drugs excessively? So the court will factor that in, and that's a big one. The court also wants to know how well a child has adjusted to their home, their school, and their religion and their community. The court is interested in this factor because they want to see basically if a child is well adjusted. And if a child is not maladjusted, then of course that's going to be a big factor. If a child is having negative reactions to their home, their community, their schools, the court wants to know about that, and that's a factor that the court has to consider. So again, the environment of the child and knowing what that is and whether it's properly suited for the child is such a big factor in this overall determination of what's in the best interest of the child. When looking at children, we're talking about children from first being born to until they become an adult. So age of a child is very important, and that's a factor that the court considers. Along with age, the court is looking at the developmental and educational needs of children at different ages. In my experience, I believe this is a tricky one because it really relies on the parents to be able to express and describe to the court what a child needs at that age and along their development. In my experience, counselors, doctors, teachers are not really interested in coming into a courtroom and testifying. If they do, it takes them away from their day-to-day activities, and they oftentimes want to be compensated financially. So the thought is, well, maybe I could just submit a letter of recommendation and put this in writing, and that has to go through a complex system of evidentiary standards. So there are some times where we could get these statements in, but a lot of times that's a tricky thing. So you want to sit down with your lawyer, make sure you understand what statements from professionals could come in to be helpful as to this factor on age and developmental needs for a child. The court's also going to look at the physical health of the parties and the minor child and the mental health of the parties and the child. Now, this factor, the court's not looking to punish people for having some sort of mental or physical illness or disability, but the court does have to look at how that overall affects the child. And what they're asking here is, does it have a negative impact on the child's intellectual, physical, or emotional well-being? So you, in this situation, would need to point specifically to situations where a parent or one of the other people is acting in a way that causes a child to have some trauma. And generally what you're looking for is whether or not the child is showing some emotional sign or distress, like crying, running away, or locking themselves in a room. That might tell you that how they're reacting or receiving information from somebody with a mental illness or even a physical illness is affecting them. The court does also, as a big factor, wants to know, has anyone here committed a crime? They're going to look at the parties, they're going to look at their significant others, and like some of these other factors, they're going to look at people who reside in the home, have resided in the home in the past, or will in the future. So a criminal record, again, we're not just looking at the parents, we're looking at the overall environment and the entire course of a child's lifetime and who the child has been exposed to. Courts just want to know, has there been criminal activity? A major factor here, unfortunately, there is cases of child abuse, and I've seen that, and that's a sad situation. Of course, if there is child abuse, that's a major factor for a court to consider. They want to know, again, does this extend to the parents, significant others, people living in the home? Domestic violence is another issue that comes up and the court explores. It's called interspousal battery in the statutes, and the court will do an examination between the two parents to determine, has that occurred in the home or is it occurring? Now, oftentimes I hear people saying, well, if there's domestic violence between the two spouses, but it wasn't pointed to the child or the child wasn't abused, what does it matter? And the parties are separated and we just needed to get them away from each other. I don't subscribe to that, and I don't think the courts do either. the apple doesn't fall too far from the tree. So the concern here is that if we have an abusive parent, that child is in that environment and they're learning these behaviors, and the child then becomes susceptible at an older age to doing these same things when they're an adult. They have children and then they act the same way that their parents did. So we want to take kids who are exposed to that environment, and if they've been in that environment, we want to address that in the court orders, making sure that the parent who was the abuser is getting help and education, and the child is now in a safe environment and learning safe behaviors. One of the last factors that a court looks at is professional reports. Now, a court can use these as factors. We addressed this a little bit earlier, so I'm talking about things like psychological evaluations, maybe a child custody study. It could even be a doctor's report. Now, if these documents are prepared by professionals and they are entered into evidence, then the court can consider that information. So again, you want to work with a lawyer to figure out, how can I get my doctor's statement about my child into the record? How can we do that the right way? The final comment that I want to make for all of you is that these factors for custody and placement, while they apply to every situation, every case is unique. I've been doing this for over 20 years, and I've never heard the same story. So the court has a catch-all factor. It says that the court can consider any other factor that the court determines to be relevant. It's hard to describe what that is because your case is unique, but I just went through these factors. So if you went through them and listened to this and you said, well, okay, I have this thing that came up, but it doesn't fit into any one of these factors that you just talked about, then this is the catch-all part for you, right? And if there's a situation that needs to be addressed, this is where you bring it up and you say to the court, hey, we went through all these factors, court, you looked at it, but this situation you also need to know about because I think it should weigh into your determination as to what's in the best interest of my child. Now, if you want to sit down with me or one of the great attorneys here at HKK Law Offices, we offer free strategy sessions. We call them complimentary consultations. We love doing family law, and I really hope you enjoyed this talk. We'll see you next time.